Chapter 6 System of Absolute Community Article 198. In case the future spouses agree in the marriage settlements that the system of absolute community shall govern their property relations during marriage, the following provisions shall be of supplementary application. Article 199. In the absence of stipulation to the contrary, the community shall consist of all present and future property of the spouses not accepted by law. Article 200. Neither spouse may renounce any inheritance without the consent of the other. In case of conflict, the court shall decide the question, after consulting the family council, if there is any. Article 201. The following shall be excluded from the community: 1. Property acquired by gratuitous title by either spouse, when it is provided by the donor or testator that it shall not become a part of the community. 2. Property inherited by either husband or wife through the death of a child by a former marriage, there being brothers or sisters of the full blood of the deceased child. 3. A portion of the property of either spouse equivalent to the presumptive legitime of the children by a former marriage. 4. Personal belongings of either spouse. However, all the fruits and income of the foregoing classes of property shall be included in the community. Article 202. Antenuptial debts of either spouse shall not be paid from the community, unless the same have redounded to the benefit of the family. Article 203. Debts contracted by both spouses or by one of them with the consent of the other shall be paid from the community. If the common property is insufficient to cover common debts, the same may be enforced against the separate property of the spouses, who shall be equally liable. Article 204. Debts contracted by either spouse without the consent of the other shall be chargeable against the community to the extent that the family may have been benefited thereby. Article 205. Indemnities that must be paid by either spouse on account of a crime or of a quasi-delict shall be paid from the common assets, without any obligation to make reimbursement. Article 206. The ownership, administration, possession, and enjoyment of the common property belong to both spouses jointly. In case of disagreement, the courts shall settle the difficulty. Article 207. Neither spouse may alienate or encumber any common property without the consent of the other. In case of unjustifiable refusal by the other spouse, the courts may grant the necessary consent. Article 208. The absolute community of property shall be dissolved on any of the grounds specified in Article 175. Article 209. When there is a separation in fact between husband and wife, without judicial approval, the provisions of Article 178 shall apply. Article 210. Upon the dissolution and liquidation of the community, the net assets shall be divided equally between the husband and the wife or their heirs. In case of legal separation or annulment of marriage, the provisions of Articles 176 and 177 shall apply to the net profits acquired during the marriage. Article 211. Liquidation of the absolute community shall be governed by the rules of court on the administration of the estate of deceased persons. Chapter 7 System of Complete Separation of Property Article 212. Should the future spouses agree in the marriage settlements that their property relations during marriage shall be based upon the system of complete separation of property, the following provisions shall supplement the marriage settlements. Article 213. Separation of property may refer to present or future property or both. It may be total or partial. In the latter case, the property not agreed upon as separate shall pertain to the conjugal partnership of gains. Article 214. Each spouse shall own, dispose of, possess, administer and enjoy his or her own separate estate, without the consent of the other. All earnings from any profession, business, or industry shall likewise belong to each spouse. Article 215. Each spouse shall proportionately bear the family expenses. Title 7 The family, N. Chapter 1 The Family as an Institution Article 216. The family is a basic social institution which public policy cherishes and protects. Article 217. Family relations shall include those, 1. Between husband and wife, 2. Between parent and child, 3. Among other ascendants and their descendants, 4. Among brothers and sisters. Article 218. The law governs family relations. No custom, practice, or agreement which is destructive of the family shall be recognized or given any effect. Article 219. Mutual aid, both moral and material, shall be rendered among members of the same family. Judicial and administrative officials shall foster this mutual assistance. Article 220. In case of doubt, all presumptions favor the solidarity of the family. Thus, every intendment of law or facts leans toward the validity of marriage, the indissolubility of the marriage bonds, the legitimacy of children, the community of property during marriage, the authority of parents over their children, and the validity of defense for any member of the family in case of unlawful aggression. Article 221. The following shall be void and of no effect: 1. Any contract for personal separation between husband and wife; 2. Every extrajudicial agreement, during marriage, for the dissolution of the conjugal partnership of gains or of the absolute community of property between husband and wife; 3. Every collusion to obtain a decree of legal separation, or of annulment of marriage; 4. Any simulated alienation of property with intent to deprive the compulsory heirs of their legitime. Article 222. No suit shall be filed or maintained between members of the same family unless it should appear that earnest efforts toward a compromise have been made, but that the same have failed, subject to the limitations in Article 2035. Chapter 2 The Family Home, N. Section 1 General Provisions Article 223. The family home is the dwelling house where a person and his family reside, and the land on which it is situated. If constituted as herein provided, the family home shall be exempt from execution, forced sale, or attachment, except as provided in Articles 232 and 243. Article 224. The family home may be established judicially or extrajudicially. Section 2 Judicial Constitution of the Family Home Article 225. The family home may be constituted by a verified petition to the court of first instance by the owner of the property, and by approval thereof by the court. Article 226. The following shall be beneficiaries of the family home: 1. The person establishing the same; 2. His or her spouse; 3. His or her parents, ascendants, descendants, brothers and sisters, whether the relationship be legitimate or otherwise, who are living in the family home and who depend upon him for support. Article 227. The family home may also be set up by an unmarried person who is the head of a family or household. Article 228. If the petitioner is married, the family home may be selected from the conjugal partnership or community property, or from the separate property of the husband, or, with the consent of the wife, from her paraphernal property. Article 229. The petition shall contain the following particulars: 1. Description of the property; 2. An estimate of its actual value; 3. A statement that the petitioner is actually residing in the premises; 4. The encumbrances thereon; 5. The names and addresses of all the creditors of the petitioner and of all mortgages and other persons who have an interest in the property; 6. The names of the other beneficiaries specified in Article 226. Article 230. Creditors, mortgages, and all other persons who have an interest in the estate shall be notified of the petition, and given an opportunity to present their objections thereto. The petition shall, moreover, be published once a week for 3 consecutive weeks in a newspaper of general circulation. Article 231. If the court finds that the actual value of the proposed family home does not exceed 20,000 pesos, or 30,000 pesos in chartered cities, and that no third person is prejudiced, the petition shall be approved. Should any creditor whose claim is unsecured oppose the establishment of the family home, the court shall grant the petition if the debtor gives sufficient security for the debt. Article 232. The family home, after its creation by virtue of judicial approval, shall be exempt from execution, forced sale, or attachment, except 1. For non-payment of taxes, or 2. In satisfaction of a judgment on a debt secured by a mortgage constituted on the immovable before or after the establishment of the family home. In case of insolvency of the person constituting the family home, the property shall not be considered one of the assets to be taken possession of by the assignee for the benefit of creditors. Article 233. The order of the court approving the establishment of the family home shall be recorded in the Registry of Property. Article 234. When there is danger that a person obliged to give support may lose his or her fortune because of grave mismanagement or on account of riotous living, his or her spouse, if any, and a majority of those entitled to be supported by him or by her may petition the court of first instance for the creation of the family home. Article 235. The family home may be sold, alienated, or encumbered by the person who has constituted the same, with the consent of his or her spouse, and with the approval of the court. However, the family home shall under no circumstances be donated as long as there are beneficiaries. In case of sale, the price, or such portion thereof as may be determined by the court shall be used in acquiring property which shall be formed into a new family home. Any sum of money obtained through an encumbrance on the family home shall be used in the interest of the beneficiaries. The court shall take measures to implement the last two provisions. Article 236. The family home may be dissolved upon the petition of the person who has constituted the same, with the written consent of his or her spouse and of at least one half of all the other beneficiaries who are 18 years of age or over. The court may grant the petition if it is satisfactorily shown that the best interest of the family requires the dissolution of the family home. Article 237. In case of legal separation or annulment of marriage, the family home shall be dissolved, and the property shall cease to be exempt from execution, forced sale, or attachment. Article 238. Upon the death of the person who has set up the family home, the same shall continue, unless he desired otherwise in his will. The heirs cannot ask for its partition during the first 10 years following the death of the person constituting the same, unless the court finds powerful reasons therefor. Article 239. The family home shall not be subject to payment of the debts of the deceased, unless in his will the contrary is stated. However, the claims mentioned in Article 232 shall not be adversely affected by the death of the person who has established the family home. Section 3 Extrajudicial creation of the family home. Article 240. The family home may be extrajudicially constituted by recording in the Registry of Property a public instrument wherein a person declares that he thereby establishes a family home out of a dwelling place with the land on which it is situated. Article 241. The declaration setting up the family home shall be under oath and shall contain 1. A statement that the claimant is the owner of, and is actually residing in the premises, 2. A description of the property, 3. An estimate of its actual value, and 4. The names of the claimant's spouse and the other beneficiaries mentioned in Article 226. Article 242. The recording in the Registry of Property of the declaration referred to in the two preceding articles is the operative act which creates the family home. Article 243. The family home extrajudicially formed shall be exempt from execution, forced sale, or attachment, except 1. For non-payment of taxes, 2. For debts incurred before the declaration was recorded in the Registry of Property, 3. for debts secured by mortgages on the premises before or after such record of the declaration. 4. For debts due to laborers, mechanics, architects, builders, material men, and others who have rendered service or furnished material for the prosecution of the building. Article 244. The provisions of Articles 226 to 228 and 235 to 238 are likewise applicable to family homes extrajudicially established. Article 245. Upon the death of the person who has extrajudicially constituted the family home, the property shall not be liable for his debts other than those mentioned in Article 243. However, he may provide in his will that the family home shall be subject to payment of debts not specified in Article 243. Article 246. No declaration for the extrajudicial establishment of the family home shall be recorded in the Registry of Property if the estimated actual value of the building and the land exceeds the amount stated in Article 231. Article 247. When a creditor whose claim is not mentioned in Article 243 obtains a judgment in his favor, and he has reasonable grounds to believe that the family home of the judgment debtor is worth more than the amount mentioned in Article 231, he may apply to the Court of First Instance for an order directing the sale of the property under execution. Article 248. The hearing on the petition, appraisal of the value of the family home, the sale under execution and other matters relative to the proceedings shall be governed by such provisions in the rules of court as the Supreme Court shall promulgate on the subject, provided they are not inconsistent with this code. Article 249. At the sale under execution referred to in the two preceding articles, no bid shall be considered unless it exceeds the amount specified in Article 231. The proceeds of the sale shall be applied in the following order: 1. To the amount mentioned in Article 231, 2. To the judgment and the costs. The excess, if any, belongs to the person constituting the family home. Article 250. The amount mentioned in Article 231 thus received by the person who has established the family home, or as much thereof as the court may determine, shall be invested in constitution of a new family home. The court shall take measures to enforce this provision. Article 251. In case of insolvency of the person creating the family home, the claims specified in Article 243 may be satisfied notwithstanding the insolvency proceedings. If the assignee has reasonable grounds to believe that the actual value of the family home exceeds the amount fixed in Article 231, he may take action under the provisions of Articles 247, 248 and 249. Chapter 3 The Family Council, N. Article 252. The Court of First Instance may, upon application of any member of the family, a relative, or a friend, appoint a family council, whose duty it shall be to advise the court, the spouses, the parents, guardians, and the family on important family questions. Article 253. The family council shall be composed of 5 members, who shall be relatives of the parties concerned. But the court may appoint 1 or 2 friends of the family. Article 254. The family council shall elect its chairman, and shall meet at the call of the latter or upon order of the court. Title 8 Paternity and Filiation Chapter 1 Legitimate Children Article 255. Children born after 180 days following the celebration of the marriage, and before 300 days following its dissolution or the separation of the spouses shall be presumed to be legitimate. Against this presumption no evidence shall be admitted other than that of the physical impossibility of the husband's having access to his wife within the first 120 days of the 300 which preceded the birth of the child. This physical impossibility may be caused, 1. By the impotence of the husband, 2. By the fact that the husband and wife were living separately, in such a way that access was not possible, 3. By the serious illness of the husband. 108a. Article 256. The child shall be presumed legitimate, although the mother may have declared against its legitimacy or may have been sentenced as an adulteress. 109. Article 257. Should the wife commit adultery at or about the time of the conception of the child, but there was no physical impossibility of access between her and her husband as set forth in Article 255, the child is prima facie presumed to be illegitimate if it appears highly improbable, for ethnic reasons, that the child is that of the husband. For the purposes of this article, the wife's adultery need not be proved in a criminal case. N. Article 258. A child born within 180 days following the celebration of the marriage is prima facie presumed to be legitimate. Such a child is conclusively presumed to be legitimate in any of these cases: 1. If the husband, before the marriage, knew of the pregnancy of the wife; 2. If he consented, being present, to the putting of his surname on the record of birth of the child; 3. If he expressly or tacitly recognized the child as his own. 110a. Article 259. If the marriage is dissolved by the death of the husband, and the mother contracted another marriage within 300 days following such death, these rules shall govern. 1. A child born before 180 days after the solemnization of the subsequent marriage is disputably presumed to have been conceived during the former marriage, provided it be born within 300 days after the death of the former husband. 2. A child born after 180 days following the celebration of the subsequent marriage is prima facie presumed to have been conceived during such marriage, even though it be born within 300 days after the death of the former husband. N. Article 260. If after a judgment annulling a marriage, the former wife should believe herself to be pregnant by the former husband, she shall, within 30 days from the time she became aware of her pregnancy, notify the former husband or his heirs of that fact. He or his heirs may ask the court to take measures to prevent a simulation of birth. The same obligation shall devolve upon a widow who believes herself to have been left pregnant by the deceased husband, or upon the wife who believes herself to be pregnant by her husband from whom she has been legally separated. N. Article 261. There is no presumption of legitimacy or illegitimacy of a child born after 300 days following the dissolution of the marriage or the separation of the spouses. Whoever alleges the legitimacy or the illegitimacy of such child must prove his allegation. N. Article 262. The heirs of the husband may impugn the legitimacy of the child only in the following cases: 1. If the husband should die before the expiration of the period fixed for bringing his action; 2. If he should die after the filing of the complaint, without having desisted from the same; 3. If the child was born after the death of the husband. 112. Article 263. The action to impugn the legitimacy of the child shall be brought within 1 year from the recording of the birth in the civil register, if the husband should be in the same place, or in a proper case, any of his heirs. If he or his heirs are absent, the period shall be 18 months if they should reside in the Philippines, and 2 years if abroad. If the birth of the child has been concealed, the term shall be counted from the discovery of the fraud. 113a. Article 264. Legitimate children shall have the right: 1. To bear the surnames of the father and of the mother; 2. To receive support from them, from their ascendants and in a proper case, from their brothers and sisters, in conformity with Article 291, 3, to the legitime and other successional rights which this code recognizes in their favor.